Following is a paid program. Advice and opinions expressed on the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands. Welcome, everybody, to Taking Care of Business, today featuring Melick Law with Rob Melick. Rob, good morning.
Good morning. Good to see you again.
Good seeing you as well. We've reached the festive season of the year. Thanksgiving time right around the corner. There's another holiday that follows that. I can't remember which one it is, but I'm sure if I walk into any store, I'll see decorations for it. But how are you handling this time of year?
Oh, it's a fun time of year. You know, we're right in the throes of hockey right now. We actually have a post-Thanksgiving hockey tournament for my older son. So he's actually got practice on Thanksgiving morning, very early in the morning, and then they have a tournament Friday, Saturday. So, yeah, it's we spend a lot of time in rinks this time of year. So wouldn't have it any other way.
Both your boys play hockey.
They do, yeah. I have a sophomore and a seventh grader. So the sophomore plays for the high school team, and the seventh grader plays club. So, yeah, we get to do quite a bit of traveling, but we're not in Beaver Dam this year. It's like the first year in probably about 6 years we're not going to make it out to Beaver Dam just based on scheduling and whatnot. Right. So it's always nice to come back here and know the whole lay of the land in this area. But
I was going to say Beaver Dam's got a nice facility. It
does.
A great place to play hockey, but being out on the ice in general is a lot of fun. What positions do they play, if I can ask?
So I have both my sons are playing wing presently, left wing. They're both left-handed, so they both play left wing. They used to play defense, so I'm a little surprised both coaches have assigned them to play wing. My younger son has played defense his entire life. This is literally the first time he's ever played wing. And my older son's about 75-25 defense, but they have him at wing, and we'll see how it goes.
Now, two left-handed kids.
Yep.
You're not left-handed?
No, we are not. Actually, the left-handed thing is actually kind of interesting. They do pretty much everything else right-handed, except they bat, they play hockey, and they golf left-handed. Because when my older son was younger, I would hold his right arm behind his back, force him to do left-handed because it's such an advantage in baseball.
Right.
And I'm such a baseball guy that having that left-handed batter works. And, of course, younger son watches older brother and sees older brother do it left-handed, so I didn't have to do anything with him. He just picked it up the way his older brother did. So, yeah, I got two left-handed sluggers and hockey players. So
there you go. And obviously that is going to come into his advantage because you're putting him on the left side.
Yeah.
That's handy.
Well, in baseball, it puts him a step closer to first base. More right-handed pitchers get to see the ball better. There's any number of advantages to being left-handed in baseball. So hockey, it's a push. It doesn't really matter too much.
Right.
But it does dictate which side of the ice you tend to play on, but beyond that, it's not really that important.
That's some good forethought that you put into there. And I'm not surprised that forethought is something that you do, considering what you do for a living, because obviously we're going to be talking estate planning, and that's one of those things where it takes forethought.
It does. I mean, it's kind of in the name, right? Estate planning. It's not estate reacting, as I like to say. So, yeah, it's one of those things where, like with anything, this is an event that is going to happen. You know, it's the difference between this area and perhaps other areas of the law may or may not happen. Right? I always talk about you may or may not ever get convicted of a crime or accused of a crime. You may or may not ever go through a divorce. You may or may not ever have a personal injury, but we're all going to pass away at some point in time. That is a given, 100% inevitability. And so, again, this is an area that everyone should at least have some awareness about, some plan in place for, because if you pass away, it's too late. And even if you become incapacitated, it's too late. I mean, that's the other thing, too. Most people just think of it as death. Well, a lot of people don't go from being lucid and incapacitated to death right away. There's usually a transition that oftentimes will involve a period of incapacity. And the problem from a legal standpoint is if you are incapacitated, you can't sign estate planning documents. You can't sign legal documents, period, because you don't have the legally required knowledge to be able to sign those documents if you're incapacitated. So, again, while death is an event that will occur inevitably, the problem is we don't know when it's going to occur. Right. So my thought is a very straightforward and logical one, in my opinion. If we don't know when this is going to occur, but we know it's going to occur, why not plan as early as possible to make sure that we have it covered for when it does occur? And that's really kind of the focus of my practice, is making sure that people have the information to know what an estate plan can do for them. Obviously, I can't dictate when they're going to pass away. I can't dictate mortality, but at the same time, we can have a plan in place for this inevitable event, and that's what I encourage people to think about.
Well, I want to give a couple numbers out for people who are watching or listening on Daily Dodge TV. You're listening on 95.3 WBEV right now. The first one I'm going to give you is Rob's number, 262-347-3444. That's the phone number you want to call if you have questions, if you're interested in scheduling a meeting with Rob and his team to start some of the conversations, be it estate planning, will and trust stuff, or even powers of attorney, which we'll talk about a little bit of all of those here on the show. So again, that number, 262 888-347-3444. If you're watching or listening and you have a question for Rob and you want to call in or text us, you can definitely do so. You can give us a call at 920-885-4446 or 920-887-9595. And that 9595 number also good for texting. We do have Ashley up in the studio standing by, and she'll be more than happy to send those calls or texts down our way so that we can try and get those questions answered for you. So I told you I'd gotten a few questions recently, and we were kind of chatting a little before the show started. And I feel like questions revolving things like power of attorney, estate planning, wills, trust, all of that seem to come up more often than we realize. And the older you get, it seems like the more common some of those conversations are. And I got kind of inundated with a few of them, and I was hoping I could bounce a few of them off of you.
Absolutely.
So the first thing somebody asked me, because I had mentioned, hey, I know a guy, you should go see him. He does estate planning, all that. And they said, what kind of a conversation do I even have with my wife before I say we should go, see about planning out an estate? He's got kids, they're grown kids. And it was just like, how do you start that conversation at home, or should you start that conversation at home before you make that conversation, that call to you?
Well, I think it's a good idea to have that conversation because it's a lot better if both people are on board with it. I mean, when I have initial consultations with a married couple, I can certainly meet with one spouse or the other, but at the end of the day, they both need to sign the documents. So I encourage people to discuss this with your spouse. And the main talking point I would look at is, what situation are they in life? I mean, you mentioned for this particular individual, they have adult children. Mm-hmm. Okay. Well, do they own a house? Are they in a situation where they need to have documents in place so that when they do pass away, the process of estate administration goes quickly, goes smoothly, and goes significantly less expensively than if they have to go through probate. Right. The other thing is, as a married couple, they don't have the ability to make medical and financial decisions for each other in the event of incapacity. That surprises a lot of people. A lot of people would just automatically assume, hey, I have a spouse. If that spouse gets incapacitated, ends up in a car accident, in a coma, in a hospital, well, of course I can make decisions. I'm the spouse. No, you can't. Not only can you not make decisions, you can't even receive any information regarding that spouse's care, prognosis, injuries, anything like that, unless we have a power of attorney, if that spouse is incapacitated. And that's the key distinction I want to draw here. It's not just in the hospital. If I go to the hospital with a broken leg, yeah, I'm in a lot of pain, but I could say, hey, call my wife and tell her what's going on. That's perfectly fine. But if I'm in the hospital and I'm incapacitated, I'm in a coma, I had a head injury, whatever the case is, and I can't express that intent, hospitals can't assume that intent. They can't assume that you would want your spouse to know, because some people don't want their spouses to know. Some people would rather rely on a child, a sibling, a family friend, whomever that person is, and not the spouse. And sharing that information without the consent of the patient, which of course the patient can't give, would be a HIPAA violation, and that could expose the court to a lawsuit for an improper HIPAA violation. So again, every single person over the age of 18 should have powers of attorney, and that includes but is not limited to married individuals. So that would be the first place I'd start the conversation. Second place I'd start the conversation is, most people work hard for their money. Most people sacrifice, they save, they work long hours, whatever the case is. In my opinion, they have earned the right to determine who gets that money with as minimal cost, time, aggravation, and perhaps most importantly, as minimal governmental interference as possible. Right. That's where a trust-based plan can help with that. So again, trusts are something that a lot of people have a lot of misunderstandings about. People think, oh my goodness, you have to be wealthy to have a trust. Well, under Wisconsin law, if you have more than $50,000 worth of probate assets and you only have a will, the estate goes to probate. Right. That surprises a lot of people. I would say the average person who has a $300,000 home, $250,000 home, who has half the equity in it, I don't think most of those people would consider themselves wealthy. Right. And they probably objectively aren't wealthy, but they sure have enough assets that if they didn't have a trust in place, the estate could go to probate. So again, it's a matter of having that first initial conversation. So for your friend who, one spouse wants to do it, the other one's a little unsure, those would be the points that I would hit. The practical aspects of not being able to make medical decisions in the face of incapacity, and making sure our assets go where we want them to go after we pass away. Those would be the 2 points I'd hit predominantly.
Good answer on that. And you touched on something very important there. That $50,000 number, depending on where you're sitting, life-wise, life story-wise, if you're renting, you have very little assets, maybe you're just freshly married, you don't have kids, you don't have much going for you, a full estate plan might seem like it's not the right time.
Right, but you need the partial estate plan, because if you're over the age of 18, we need those people to make those decisions as far as powers of attorney. So again, you're right. Not everybody needs a trust-based estate plan. That's a true statement. But everybody over the age of 18 needs some form of estate planning, even if it's just in the form of a health care and a financial power of attorney. And again, that's what I do at my law firm, is I educate people. That's what I'm doing on the show, actually, educating people about what the actual what an estate plan can actually do for you, as opposed to what people think an estate plan can do. Because what I've learned in my practice is there's such a huge disparity between what people think a plan can do and what a plan actually can do.
Right.
And that's what I try to do. I try to bridge that gap and give people information, because again, estate plans evolve with time. I mean, that, newly married couple you just described living on a shoestring, maybe they have kids one day. Maybe they buy a house one day. Maybe they have more than $50,000 worth of equity today. And the estate plan needs to change as life events change. I mean, if I go back for myself 20 years and look what my estate plan would have been then, 20 years ago, I wasn't married. 20 years ago, I was in law school. I didn't have kids. I mean, there's any number of things that were different 20 years ago, and 20 years from now may be different. Maybe 20 years from now, I have grandchildren. Maybe I'm retiring. I don't know. I mean, there's so many variables that come into play with that an estate plan, and not only the estate plan itself, but the choice of which estate plan is best for you certainly evolves as life progresses.
So I heard somebody say once, and I was pretty sure that they were incorrect in this, and I voiced that, but then suggested they speak to somebody who's more knowledgeable than me. They had said, well, I don't want to make anybody my financial, estate, my plan or the
power of attorney?
The power of attorney for my finances, because if I have a lot of debt and they're the power of attorney over it, then they're assuming that debt.
That's 100% false.
Okay.
And I can tell you why it's false. For two reasons. First of all, because under Wisconsin law, the debts of the decedent, which is just a fancy word for the person who passed away,
right,
are limited to the extent of the assets of the decedent. Nobody's required to go into pocket, right? I mean, forget the power of attorney for a second. If I was in a situation where, I had $10,000 to my name and I had $100,000 worth of medical bills, nobody's responsible for that remaining $90,000. Of course, the $10,000 has to be paid.
Right.
Nobody can profit from that, but the remainder does not have to be made up by anybody, let alone a power of attorney. The other thing about power of attorney is under Wisconsin law, powers of attorney terminate at death anyway. So that person couldn't be responsible because their authority ends the moment that person passes away. So, yeah, unfortunately, that's 100% not true. I don't even know where to start with that one. So I just kind of gave a broad overview there. But, yeah, no, not true at all.
That's the joy of people maybe not understanding the definitions of phrasings and things. But that's why, obviously, you talk to somebody who is a lawyer who understands this, and not your neighbor who
exactly
the third thing, fourth thing.
Exactly, and I find that interesting because for whatever, and this is going to sound like I have a chip on my shoulder about it, but I really don't. But it's like there's no other area of law where you would do that. You wouldn't say, well, this person on a criminal defense side could argue this, this, and this, or in a personal injury they should argue this, that, and you would certainly never say that to a medical doctor. Here, doc, here's how you should conduct the brain surgery. Like it doesn't work that way, right? But for estate planning, everybody reads an internet article, they go on ChatGPT, and they find themselves experts on it. And again, it's not an ego thing for me. It's just making sure people have full and complete information, and that would be like the equivalent of pretending you're a doctor by reading some WebMD articles. It's just not the case.
You touched on something that's actually one of my questions. I was very, so I'll jump to it now. Somebody had said, well, what if I just have AI write my will or my estate plan? Nowadays it's so good. It searches the internet. It finds all the information. It finds all the the legal ease or whatever. Does that even hold up? Is that something that can be done?
I mean, I have no idea. It would depend on what the AI derived. What I can tell you is if you have a question about that on a random Tuesday night, AI is not going to answer the phone. You're not going to be able to adapt it as time goes on. You have to let AI know the inputs in order for them to be able to spit out the results. I could type me a will. Well, if I have a will, most of the time that's going to end up going through probate. If we have more than $50,000 worth of probate assets, it will go through probate. So what the attorney does is provides the knowledge gap between what the client thinks they know and what the law actually is. There's no AI machine in the world that can do that, and I don't anticipate that ever occurring. Now, if you have the knowledge to say, hey, type in create a revocable living trust that does these things, that allows for this, you have to have that specific knowledge to be able to get to that point. And again, most people simply don't have it. I mean, the analogy I draw is, there's a reason why if my engine goes in my car, my transmission goes, I don't fix it myself. I go to a mechanic to make sure it's done correctly. It's the same kind of logic when it comes to estate planning.
Right. And of course, you're not going to type in, change my brakes and an AI walk away and it does it for you.
And yeah, not only that, but and that's the other thing too. Like you can get information. I mean, I'm sure I could type into my phone right now how to change a transmission into YouTube, and I'll probably get any number of videos. I still have to do the work. I still have to do everything right. And again, these people have experience. They have knowledge. They have stuff that on the job training. All these things I can't possibly replicate about machines. So. I don't know. Maybe if I'm wrong in 10 years, people will pull up this clip and show me how dead wrong I am as AI takes over everything. I can't predict that, but in my opinion, and it's also the relationship too. I mean, that's one thing that I've learned in my 18 years of practice. People want to have the relationship with the lawyer because they know how important this is. They know this is something that is going to happen, and they're not going to be around to see it. That's the other thing I always talk about with my practice compared to other practices, right? If I'm accused of a crime, I can see my criminal defense attorney, and I can see the result of his or her work, right? With estate planning, I mean, yeah, you can see the end product, but at the end of the day, you're not going to know if it's going to work until it's after you're deceased at that point in time. And again, with the AI, who knows? But when you have attorneys that have been doing this for a long time and have many clients and focus only exclusively on those areas, the likelihood that it's going to be done correctly is exceedingly high at that point in time.
Well, and there's also, and I'll touch on this because you've mentioned it before, but when you draw up estate plans, you draw them up to be guaranteed to avoid probate.
That's right. Again, assuming my clients follow my directions.
Right.
That's the key underpinning there. It's the cliche, I can lead the horse to water, but I can't force it to drink. So assuming my clients do follow my instructions, then yes, that is the idea. Because again, probate, let's just talk about probate really quickly. What is probate? Probate's the process where a court oversees the administration of an estate. Estate goes to probate. You get a series of hearings, series of filings, series of deadlines, series of events occur, but that before assets go from the name of the deceased to the name of your intended beneficiaries. The reasons I encourage my clients to create plans that avoid probate, three main reasons. First, probate's expensive. Average cost of probate in the state's about 8 to 12 grand. Second is timing. Average length of probate's about 12 to 18 months. Third negative is it all becomes public record. Not only does the will become public record, but the amount and the character of the assets also become public record. So again, avoiding probate is very important. And again, if we have more than 50, as I mentioned before, $50,000 worth of probate assets, the estate goes to probate. So I'd argue the overwhelming majority of the listening audience here, who either A, has no estate plan, or B, only has a will-based plan, those estates are likely going to go to probate because they have they have more than $50,000 worth of probate assets. So again, what I encourage everybody to do is kind of take an assessment of your situation, see where you're at, and ask me any questions. And again, at my firm, you gave out the number earlier, but what I tell you at my firm is I never charge for initial consultations. Initial consultations are always free. It's not even just a perk of listening to WBEV. Right. It's something that I offer to everybody because what I've learned in my practice is there are already so many barriers to getting people to come to meet with me as an estate planning attorney. And it's not just me; it's every estate planning attorney. People just don't want to think of their own mortality. They don't want to worry about the cost. There's any number of reasons people don't want to make that appointment. But at least getting that information, I'm never going to charge you for that. I'm going to do it for free. And again, whether you come to me in one of two spots, either you have existing documents that you want a second opinion on, or maybe you have no documents whatsoever. Either way, the initial consultation is free. Because I have a lot of people who come to me with what they know are old documents. Well, the good news is, and the analogy I always say here is that estate planning documents are not like a gallon of milk, right? They don't have a defined expiration date, okay? But time changes. Laws change, preferences change, so they may need to be updated to reflect those preferences. But either way, at my firm, I always give that free initial consultation to review those documents and say, okay, here's how the documents read presently. Okay, if there's something you want changed, then we can flag it, we can mark it, and then we can come up with a corresponding price based upon the changes that we need to the existing documents. If, on the other hand, you start with nothing, then we could talk about an estate plan. And the other thing is, at my firm, when I either revise a document or draft a document, I do not charge for revisions if they're part of a trust-based plan. So again, powers of attorney I reserve the right to charge for that. But if people create a trust-based plan, they are getting probate avoidance for life, at least as long as I live. So, there is something to that. And for people not watching or people who are watching who don't know, I'm 44. I intend to practice for a long time. So I always tell my clients that kind of promise from a 44-year-old is worth more than maybe an attorney who's in their 60s or 70s. Right. But I enjoy what I do for a living, so I intend to do it for a while.
On a personal note, the fact that you're only 2 years older than me and I look older than you, you must be doing something right.
It's all relative there, man.
Again, 262-347-3444 if you want to call and schedule that initial consultation with Rob and his team at Melick Law. You touched on something when you were mentioning probate, when you said not only is it, that it becomes public knowledge, the amount, but the nature of the assets as well. And I was joking with somebody because they said, well, what exactly does that mean? And I said, well, technically, from what Rob told me, it means that, like, if each of your kids gets $50,000, now everybody knows your kids got $50,000. Right. And they may know your kids and know which kids are the right kids to buddy up with and get their hands on some of that.
Absolutely.
But it's also the nature of the assets. And so jokingly, I was like, if you know that, Aunt so-and-so's got, $40,000 in Labubus, now everybody knows she had $40,000 in Labubus.
No, and that's exactly what it is. And I mean, if you ask most people, they'd be like, why is that the government's business? Why is that nosy neighbor's business? And the short answer is it isn't. But if it goes through probate, it becomes their business because it's public record at that point.
Right. Want to talk about a possibility that could come up, and I know several families that are in this boat, and I don't know if they have estate plans or not, but blended families are becoming more and more of a thing.
For sure.
And even in instances where, in the case of the family I know, husband and wife got married, then they got divorced, they're still friends, they still interact on a regular basis. He got remarried, she got remarried, they have shared kids together. When it comes to estate planning, does that complicate things?
I wouldn't say it complicates things. It's something that needs to be addressed. I mean, because basically the idea is this, and where it typically tends to get addressed is when we have a disparate number of children. I'll give you an example. Okay, so let's say we'll say Betty and Barney. We'll make a Flintstones reference here, right? So Betty and Barney, let's just say it was their second marriage. Okay, and let's say Betty came into the marriage with 2 children and Barney came into the marriage with 3 children. Okay. And let's say they say, all right, we want it divided among our children. Well, what does divided among the children mean? It could mean 20% to each, or it could mean 50% to Betty's children, 50% to Barney's children. There's no right or wrong answer, but that's a huge difference in terms of where it goes. The other thing would be what happens to a deceased child's share. In other words, if one of Barney's children passes away, does it get divided evenly among all the children, or does it only get divided among Barney's children? The final thing there would be, do we want to eliminate a surviving spouse's ability to make changes? In other words, if Barney dies and Betty's now in a situation, Betty could just cut out Barney's kids if she wanted to. Right. But we can't turn the water faucet on or off. In other words, it's not like we could say, well, at this point they can't make those changes, but then all of a sudden they can. So, because once that one person passes away, if we put that term in there, it's irreversible. So, again, pros and cons to that. But I walk my clients through that. And the other thing is that also assumes that there was no prenup or postnuptial agreement. Because if there's a prenuptial or a postnuptial agreement, that'll change that analysis as well. What I always tell my clients is there's a pre or postnuptial agreement. I, as the estate planning attorney, have to work around the contours of that. Because what is a pre or postnuptial agreement at its core? It is the couple agreeing to stray from Wisconsin marital property laws. Right. And if both parties agree, they can absolutely do that. The question then becomes how, if at all, are any assets going to be considered joint assets subject to division in the estate plan, or how do we account for the pre- or post-nuptial agreement in the trust itself? That's basically what we're looking at there.
Now that then touches on something else. So obviously, if me and my wife have an estate plan, it's our estate plan. And if one of us passes away, that estate plan is still in place.
Absolutely.
It's just minus one spouse.
That's right.
Are there instances where people might do individualized estate plans?
Typically not. Very uncommon. It can happen. Typically in the case of where people have prenuptial agreements, there it's more common because, again, under Wisconsin marital property law, there's a presumption that in the absence of a pre- or postnuptial agreement, all assets are joint. There's some exceptions to that, inherited property, things like that. But as a general rule, assets acquired during the course of the marriage, regardless of whose name they're in, regardless of who earned them, they're typically considered marital assets. So that's why the overwhelming majority of the time we would have a joint trust there. But it's not impossible.
Speaking of assets, lately, of course, things that could be considered assets, I think, have changed a little bit now when we talk about wealth. Digital wealth is coming into play. Cryptocurrencies, NFTs, digital art, whatever. Is that something there are now provisions for in estate planning?
Yes and no. I mean, what's interesting is I had a client who had crypto the other day. I forget which. I think it was Bitcoin, if I'm not mistaken. But what I found out there and doing some research is that Bitcoin will not let you list a trust as a beneficiary. So you have to play by their rules is the issue, right? So Wisconsin in particular, but any state would have laws regarding how those assets go. But the problem is you have to play by that entity's rules. In other words, a bank can put any requirement they want. Bitcoin can put any requirement they want on there. But again, having that digital key, as they call it, to be able to access the digital wallet, all these things come into play. I mean, we always do put general provisions into our estate planning documents about digital property. But again, it's incumbent that we find out that particular platform, what their rules are and how assets can be titled. I mean, I give general advice there, but I leave it to my clients to be able to find out, okay, what does this particular platform do? And at the end of the day, as callous as this might sound, if you don't like the rules of that system, find a different system. Pull your money out of there and find something else, or live with the potential risk that it may not go the way you want it to go.
Yeah, because I mean, crypto, especially, I'm thinking Bitcoin, especially, that digital wallet, if you lose your logins, your passwords, whatever for it, you have no access.
That's a big problem.
There's no recovery for it, and that's just out there in the ether.
Sure.
So, yeah, that was one that kind of came up, and I thought, it's one I hadn't thought of.
You bet.
Is there a difference with how people approach estate planning generationally?
Oh, 100%. The biggest rule that I find is as a general rule, there's always exceptions. I mean, it's like you said, generalization, right? Generally speaking, the older the individual, the more private they are. Okay. So what I encourage in my practice is family meetings, especially if there's going to be potentially hard feelings about who's going to be in charge or disparate distribution, things like that. I encourage family meetings, and those encouragements tend to be more successful the younger my clients are. It's just the way people were raised. I mean, it's one of those things where obviously as I get older, the number of people older than me go down, of course. But, it's one of those things where I just see that a lot, where just that older generation, the generation now in their late 70s, early 80s, you don't talk about money. It's just not something you do. People just weren't comfortable with it. And so, I've had clients where the younger child who's, in their 50s at this point or whatever is the one who arranges the meeting, and they'll ask that child to leave the meeting if some stuff comes up that they want to talk about. And you don't see that among people our age. It just doesn't happen, So that would be the one thing I noticed too. I do think that my generation of people who do the most planning relative to time is probably people between their mid 40s and their mid 50s. That's the group that, again, typically doesn't have an estate plan when they come meet with me, but they're typically the group that sees the value in creating it. I mean, usually, I think they say people's peak earning years are between, I want to say, like 48 and 54. That's what I've heard. I don't know if that's true, but that's what I've heard. That's generally where you get to a point in your career. You're kind of on the ascension, and then after 54, you tend to either decline in your career, either by choice or just by whatever, the passage of time. You're not as hungry as you used to be. I mean, there's any number of variables that come into it. Maybe your kids are out of college at that point. You don't have the need to earn as much money, whatever the variables are. But that's kind of the age that, because normally when I meet with clients, again, always exceptions through, but generally when I meet with clients over 65, they almost always have some form of estate plan. It may have been 30 years ago before they're going to Hawaii. They just drew a quick will together for the now 40-year-old kids.
In case something happens on the plane
exactly,
right over.
Something like that. But that's, again, but they typically have something, whereas most people that age don't. And just the idea of being able to encourage people to understand, people in their 30s, 40s, most people would think, well, I don't need an estate plan. I'm too young for that. But just explaining, as we're doing on this show, the importance of having those documents at that age is something that I put a lot of emphasis on my practice, because for whatever reason, mainstream society hasn't done that. Again, if you asked your average 65-year-old, approaching retirement, whatever the case is, they should probably have some sort of estate plan. They may not know what to do. They may rely on something that's completely inadequate, but they at least know it's a, for lack of a better phrase, good idea.
Right.
that is not the same with people who are about our age or even a little younger than us. It doesn't resonate. It's the idea of, well, what are the likelihoods? And what I always tell my clients is, I don't know what the likelihood is, but I know it's not zero.
Right.
I know that the likelihood of passing away in your 40s is low, but it's not zero. Because it's not zero, we should have a plan in place. And again, at my firm, if we have that plan in place and there are those life changes, I don't charge for those revisions. So that's something that I offer as a value add. And again, as I mentioned earlier, I'll just mention again, always have free initial consultations, and I can do those anywhere. I have 4 offices. For most people in the listening and viewing audience, it would be the Beaver Dam office where the hires work out of. But I also have my main office in Saukville and then satellite offices in Germantown and West Bend. Free initial consultation. We could do it by phone. We could do it by Zoom. We could do it by in-person visits. I make house calls. And also 20% discount for WBEV listeners. So if you do elect to call, and you do elect to create documents with me, mention you heard about me on WBEV or saw me on dailydodge.com, and we'll get you a 20% discount off legal fees.
There you go. I'm going to share that number again for anybody who hasn't been listening the entire show. 262-347-3444 for Melick Law. I'm going to talk a little bit about time frame. When people are writing up documents, you talk about like, oh, we're making a trip to Hawaii. Let's just write up something we did 30 years ago. Planning a little bit ahead. But what is the average time frame for somebody to come in from that initial consultation to we've got a legal document in place that if something happened now, you'd be covered?
Sure. As a good lawyer, I have to make a few assumptions in answering that question. Assumption number one is that the client in this example decides to go forward at that meeting. Okay, and then the second assumption tied into that is not only do they decide to go forward, but they have all of the information necessary to go forward. Because, again, I don't require a lot of information. A lot of other attorneys require a lot more information than I do. What I would say is among people who see me on that first initial consultation who decide to go forward, they either have all the information that day or they can get it within a day or two. Right. So what I always tell my clients is, to answer your question, the clock effectively starts the moment I have all the information, because I could be with somebody today and then I don't hear from them until January that they want to go forward, right? And that's their prerogative. Take as long as you need to make decisions. Ask me any questions you want to help you make those decisions. But I'm just saying that the clock kind of starts rolling once I know the client is going forward and I have all the information to draft their documents. But usually speaking, my turnaround time is about a week and a half to 2 weeks. Depending on workflow, sometimes it can be less than that. And I do what I call triage situations. I'll give you an example. I met with a client who was in the ICU. We met on Sunday this week. They called me on Thursday. We drafted the documents. I met over there on Sunday, had a witness with me. It was just easy. I mean, it was something that had to be done because, again, she was lucid, because that's the key thing. That's the first question I ask. Does this person have capacity? And unfortunately, I can't just take people's word for it. But I went in the hotel. I went to the hospital room, and I introduced myself. We were able to communicate, so I had no doubt as to her capacity. I mean, she wasn't doing well physically, clearly, but she had the requisite mental capacity to be able to execute the document. So that's the important thing. But again, that's just an example of triaging situations. Somebody's going on a trip. We can find a way to get them in earlier, but the general turnaround time is about a week and a half.
That's actually not bad. I mean, I would have thought this would be a longer draw. But really, then that falls on the client. If I'm taking forever to get you the documentation or to get information you need.
Exactly. Yeah. And again, I don't want to make it sound like I'm pressuring people. In fact, it's the opposite. I encourage people to take as long as they need to be fully informed and to be confident they made the right decision, not only to create an estate plan, but to create an estate plan with me. Because it's like anything else. There's a personality fit, and it's very important, especially in the realm of estate planning, because those life events do change. Is this someone you're going to feel confident dealing with? Is this someone who you're going to be able to call and actually get a hold of and not be passed off to a paralegal and have an appointment 3 months from now? These are things that I take pride in my practice. I have 3 outstanding paralegals who help me with the drafting and help me with all of this, intakes, all that good stuff. So, again, I'm intimately involved throughout the whole process. I'm there for the initial consult. I review the documents. I'm there for the signing. I'm there to answer any questions. So again, if you're deciding between attorneys, these are important questions to ask, and make sure that the attorney you choose, you feel confident that he or she is going to be the one involved. Because again, nothing against my paralegals. They're awesome, but they're not lawyers. And so especially I feel like in the estate planning world, that relationship between the actual attorney and the client is a very important one. And that's not something, I don't care how big my practice gets, I'm never going to lose sight of that, because that's what people pay the money for.
2 things that stand out to me. One, admirable that you are the type of estate lawyer where you're like, hey, I want to make sure there is capacity there, because you think about TV shows and movies where you get that shady, ambulance chasing lawyer who, can they half nod their head or blink once for yes,
Right.
twice for no, that sort of thing. Oh, look, they said yes twice. And so actually being the one that's out there seeking capacity is admirable. Two, I love the fact that you touch on the fact that your paralegals, while very skilled, are not lawyers. A lawyer's still looking at it. A lawyer's still looking at that information because, like you've said, this document doesn't go into effect until after you're gone.
Right.
And so knowing and trusting that you have the knowledge and the skill to draft it properly, because you're not going to be here to see if something didn't work.
That's exactly right. I mean, first of all, it's the right thing to do, but more importantly, my name's on every single document. Right. That's, as the lawyer who drafted it, I have to take pride in my work, and I have to make sure that work is done correctly and to my client's satisfaction, and that they truly understand the value of having these documents. Again, because I get asked that a lot, I don't need my clients to be experts in estate planning. Mm-hmm. I need them to understand why they are better for having these documents than not having these documents. That's really my standard. If I can articulate to them and they can believe that they are better off for having them than not having them, then I've done my job.
What would you say is the biggest misinformation or misconception people have that you have to dispel when you sit down with them the first time?
Yeah, I'd say the biggest one is the differences between will-based planning and trust-based planning. Most people just think will-based planning is enough. They don't need trust. Trusts are only for wealthy people, and as we've explained throughout the show, that simply is not the case. Probate avoidance is a big thing. It's very important. Again, we talked about the expense, $8,000 to $12,000 on average, 12 to 18 months. I'd say most people that I meet with, when I initially meet with them, they come into that meeting believing that a will is going to be sufficient. So that's by far the biggest misconception. I'd say the most dangerous misconception is with respect to guardianship of minor children. Mm-hmm. That's so many people who have minor children, myself included. I have two boys who are 15 and 13. The most important thing an estate plan can do for people in my situation, your situation, I know you have children under 18 also, is guardianship of the minor children if the parents pass away. There is literally nothing more important. And so many people have the misconception, again, fueled by TV, unfortunately, a lot, the fact that, oh, well, if I have a written statement that's notarized that my brother or my sister gets the kids, or my mom, my dad, completely unenforceable in Wisconsin. The only way to determine guardianship of minor children is through either a will or a trust. Literally nothing else works. So that's a big misconception as well. And again, it's just one of those things where, as a parent, I would like to know about that. What I always say is, if I did anything else for a living other than what I do, right, and I was sitting here today and I heard an estate planning attorney say that, first of all, I would be skeptical. I would do my own research probably. But once I found out that he or she, the attorney, that he or she was right, I'd be like, I need to get this protected like yesterday.
Right.
I need to have documents drafted that would allow for that to happen. Because again, you can go back to the statistics. Is that likely to happen? No. Is it likely my wife and I are both going to pass away prior to Hudson, my youngest son, turning 18 in 5 years? No, it's not likely.
Right.
But it's not a 0% chance either. It's somewhere north of zero, and it's going to happen to somebody. It happens to somebody every single day.
Right.
Why not take the time and the effort and the money to make sure that if it does happen, we get to determine where our kids go? Because again, nothing's more important than that. And I'd even argue from a guardianship standpoint, it may not even necessarily be who gets the kids, but the more important thing might be who doesn't get the kids.
Right.
And being able to establish that, because we can't speak from beyond the grave. We haven't mastered that technology yet, nor do I think it would ever be reliable, even if we did. The idea is that we as parents should, in my opinion, have the obligation to determine conclusively whom we would want to serve as guardians if we don't make it to a child or children's 18th birthday.
I guess I hadn't thought of it that way, but you made a really good point with the who doesn't, because I know plenty of people who, as adults, are like, I get along with my parents great now that I'm an adult, but I hated my childhood, or I hated how I was raised. I don't think my parents can handle it. Or I don't think my parents are, are the kind of people who want to take on kids at this age.
And it can change over time. I mean, the example I give is this, 15 years ago, everybody was 15 years younger.
Right.
There's a difference between raising a baby when adult parents are 15 years younger than they are now. There's a big gap between what happens at 60 and 75. Big gap between 50 and 70 in terms of parents' ability, in terms of their motivation, in terms of their activity level. I mean, there's a whole lot of things that go on. And the opposite is true too. You might have younger siblings who were in their, late teens or early 20s at the time you had your children. Well, now 15 years later, maybe they have children of their own and they turn out to be wonderful parents. They're living the college life or the bachelor life when you first have kids, but now they're phenomenal parents. And you say, gee, that's where I'd want my kids to go. It can change over time.
Right.
And that's the other point I want to emphasize that I know I've talked about a lot here too, is making sure that the estate planning documents reflect your current position, making sure that they're updated. And again, at my firm, when you do the trust-based plan, there are no charges for those revisions. So as those events go on, we have the ability to make those changes over time. One of the things I talk about is 3 Ds and a B. 4 life events that frequently will cause people to want to update their estate planning documents: death, divorce, disability, and birth. So those 4 life events and any other can be accounted for and updated accordingly.
Now, we've talked about this before, but I want to mention it again. You have a system in place where if somebody comes to you and let's say at the time they don't have that more than $50,000 in assets, the will-based plan is the right way to go for them. So they do that, but then they come back and see you later and say, now I need an estate plan. You have like a program where you kind of credit that value up.
Yeah, I call it built-in credit. So whatever people pay in time one for services, they get as a discount off the cost of time two. Again, my prices aren't going to stay the same. Nobody's prices stay the same. Right. But you get that built-in credit off those services, and can actually even be 3 levels. I've had a bunch of clients where it's at 3 levels. They start with just powers of attorney once they turn 18. They get basic wills once they have children for guardianship, and then they get to a point where they want to create a trust. So the built-in credit passes down over time. Because again, those life circumstances change. The goals of an estate plan for an 18-year-old are markedly different from the goals of an estate plan for a couple who owns a home and has children. They're night and day different.
My last question for you before we start to wrap up today, obviously when it comes to legal documents, a lot of times the concept is you want to be as specific as possible because ambiguity just leads to speculation and misunderstanding and generally doesn't favor the people drafting the document. How specific or general can you be in these documents?
As general or specific as you want. I mean, the example I give there is, a lot of people just have a distribution 50-50 between my 2 kids. Done. Easy. Over. I mean, you put in contingencies. If a child predeceases, do we want to go into their children? Do we want to go into the surviving child? How old do we want minor beneficiaries to be? So I'm oversimplifying it there. But if people want specific distributions of items, they can certainly have that in place. It's just
like all the way down to, well, so-and-so really likes grandma's old antique salt shakers.
Absolutely. So. And what I always tell my clients is that there's a difference between a moral obligation and a legal obligation. If you feel a legal obligation is necessary because of family dynamics, because of potential family dynamics, whatever the case is, make it legal. Put it in the document. Guarantee its enforceability. On the other hand, if you believe putting stickers on the bottom of things is going to be sufficient, I say it can be. Right. It's not legally sufficient, but it may be morally sufficient, and that may be good enough. But those are the types of things that I walk my clients through.
That's awesome. I want to remind everybody again, they can find you via the phone number, of course, 262-347-3444. You have the 4 locations. Run through those again.
Yeah, so my main office is in Saukville, but for most people on the listening and viewing audience, Beaver Dam with Sandy and Matt Heyer. But I do also have locations in Germantown and West Bend. Again, free initial consultation for anybody. We can make house calls. We can make virtual visits, Zoom, telephone calls, whatever the case is. And also 20% discount for WBEV listeners.
And your online presence.
Yeah, so website is www.melick, M as in Mary, E-L-I-C-K, lawwi.com. So it's M as in Mary, ELICKLAWWI.com.
There you go. Well, Rob, it's always a pleasure having you on the show. Always very informative and very eye-opening in some of these conversations, which they should be. These are hard, tough conversations, but I think you're the right guy to have those conversations with.
I appreciate that. Thank you.
Thank you. This has been a paid program. The advice and opinions expressed on the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands.